Hello and welcome to PM Express. Today, two journalists might spend the night in a medium security prison or jail, probably in Sewon prison. The offense is criminal contempt. Defined editor of the Searchlight newspaper, Ken Crunchy, is going in for 10 days, whilst a member of the NDC's communications team, Stephen Atubiga, gets 3 days. A third person, Kweku Buohene, who was also whisked before the Supreme Court, was discharged. However, there have been questions over whether the jail term in the exercise of the powers of the Supreme Court constitutes a threat to freedom of speech. As the chairman of the Supreme Court read out the decision of the court, it was clear that for showing little or no remorse, Ken Crunchy had the hardest bite and is getting more days in jail than his other colleague. So, what are the legal implications of this? What constitutes contempt? Must journalists be cowed by this sentence? And what is expected to be the pattern of reportage following this rather very direct exercise of the powers of the Supreme Court? My name is Nana Sakwa, and I'm going to take a quick break. When I come back, I will introduce to you my guest, and then the conversation begins. Stay tuned. Hello and welcome back to the show. Today we're discussing, is free speech under threat? The very basis of every civilized institution, country, whatever, is the ability to have free speech, to be able to see something, and if your conscience tells you is right, you should be able to say it. If your conscience tells you is wrong, you should be able to say it. But what we're asking is, with what went on in the court today, does it affect that? Is our civilization going back in reverse gear? With me in the studio to discuss this, to my immediate left is Dr. Lawyer Maurice Ampao. And then to my extreme left is our own brother, Samson Ladi Ayenini, a lawyer, host of the News File show, and also a former Joy FM news editor. So he's a brother in the house, but they are all lawyers. Joining us on the phone later is Yao Buedu Ayebuafo, who's a general manager for the Graphic Communication Group. He will join us later. He's also a lawyer. I will start with Samson. Contempt and criminal contempt. First of all, now go easy on the legal jargon. Yeah, go easy on the legal jargon. This is, yeah. So we want to know what contempt is, and then what is criminal contempt.
All right. When we say contempt, basically, we are, and you start by differentiating it yourself. When we say contempt, we have contempt in two forms: civil contempt and criminal contempt. Even the civil contempt is what we often refer to as quasi-criminal, also because contempt proceedings, committal proceedings, are normally instituted in the name of the Republic. So you would always find the Republic versus against, so to speak. Now, in civil contempt, we are simply referring to someone's disobedience or defiance of the orders of the courts or the judgments of the courts. When a court gives an order, for example, if the court places an injunction on you not to step foot on the premises of multimedia and you decide to defy it, you are in contempt of the court. Now, the owners of multimedia can properly draw the attention of the court to your behavior through the process that we call committal for contempt. And through that process, if it is brought to the attention of the court and the court finds that you have indeed breached its orders or you have refused to obey its judgment, you will be punished for that.
Then
criminal contempt often has to do with acts that you engage in which the court sees as obstructing or interfering with the administration of justice. And criminal contempt popularly looked at in respect of the matters that we are coming to discuss. Touching on the matters that we are coming to discuss vis-a-vis the Supreme Court is the contempt that the judges or jurists have defined as the criminal contempt of scandalizing the court or scurrilous abuse of the court or its officers, especially the judges. So that the court, for example, has held Stephen Atubiga to be in contempt of it. This kind of contempt is the contempt of the criminal contempt to the point of scandalizing the court. His comments were to the effect that even if the court gave a judgment, and this is the final court of the land, even if the court gave a judgment that the NPP had won the petition, the president will not vacate the office of the presidency, and that they were ready, they were not going to sit down, sit aloof, his words, and watch the NPP take over. And that he also said things to the effect that even if it happened so, the country could not contain, the NPP and the NDC. The court held him in contempt of those comments, which he apologized, retracted, and sought mercy, and ended up mitigating the punishment that he would have suffered. So contempt, so to speak, this is how it manifests itself, more particularly when matters are pending before the courts and you comment on the matters. It is not just comment, but commenting on the merits of the matter that is pending before the court. The court presently is looking at the election petition. The witnesses, Dr. Baumia, Esedum Ketia, Farijan, who have appeared to adduce evidence, facts. Now, the question of facts is a question for what we normally say in law is a question for the determination of the jury. That is, if it's in a criminal proceeding. But the question of law is a question that is in the domain. It is in the exclusive preserve of the justices to determine. So if you make comment that seek to take away that authority from them, and you seek to sit in judgment of the case itself, you'll be held in contempt.
Samson, let me stop you there. Doctor, once upon a time, there's this watchman in Emprise, and he has a scuffle with his boss, so he tells his boss, I'll shoot you. And so the boss takes him to the magistrate, and they, bring the watchman there, and he says, my mouth be gone. Mm-hmm. I just said I will shoot him. I don't even have a gun. So the one asked, Atuguba was blowing hot air. He's just saying, the president won't vacate, I will lead a demonstration, and this and that. If I buy a car, I'll sit in front. Oh no, get out from my car, even though I haven't bought it. Why is he in court? Is freedom of speech under threat?
Thank you very much. Greetings to your viewers. I think what we have to, the signal that we have to send clearly to the public is simple. You see, the judges are not worried about the comments. The judges are not worried about the threats because they are unshakable. They are above. They have the capacity to take it because nobody can influence them. They are exercising a constitutional duty, which says that as they sit in judgment, they cannot be directed and controlled by anybody. As they sit in judgment, you can't remember that even the petition that was sent to the Chief Justice, they ignore it. They didn't even put a weight. They are so powerful that nobody can influence them. But there you realize that Justice Atuga said something. Their concern is the ordinary person on the street who can easily be influenced by these comments. Because if you make a statement to the fact that, look, we are not going to accept the verdict because nobody can be declared a president based on a clean sheet, then you prepare the minds of your supporters that if they dare, which they can, you will take an action not against anybody, but also it can be a threat on their life because they are the ones who have declared. Therefore, people can charge on them. And then also, the other person will suffer. So they are more worried about securing the safety of all, especially the other person on the street. Therefore, whatever they are doing in holding the authority of the state, in ensuring that the dignity of the state is preserved, is protected, is for the common good of all. That we live in a society where we should not descend so strongly on the judiciary to the extent that they will lose authority, they will lose control, that now when you have a matter, you don't know where to take it to. You realize that in this country, every institution has been run down. Take the police, it has been run down. Even the military, run down. Chieftain institutions have been run down. The clergies have been run down. Almost all the institutions have been run down, politicizing every issue. Now, when we begin to descend heavily on the judiciary, what we are doing is that we are seeking to create anarchy, because then, if you have a matter and the judges are threatened, or don't have the authority to determine the matter, then every matter will be decided by the stronger person in society. So, it is for our own good that the Supreme Court decides to stamp the authority on the matter. So I don't think that freedom of speech is a threat at all. Because at the end of the day, I always say that your freedom is not your freedom. What is freedom? Your freedom is not more and better than the security of the state. Because take your freedom in a state where there is anarchy. Where lies your freedom? So your freedom of speech cannot be equated to the right to protect, or the duty of the court to protect the sanctity of the state, the authority of the state, the stability of the state we find ourselves in. So therefore, definitely, when we talk about freedom, I feel so sad when I see lawyers trying to push. And you quite remember, the justices said today that look, they are champions of freedom of speech. They are there to protect people who right to freedom of expression has been. And they have shown that they are there for the other person to protect people's rights. But when it comes to the authority and the security of the state, they will not sit down for people to turn this country into an anarchic state.
Mr. Yao Buadu Ayabuafu joins us on the phone. Mr. Buadu, can you hear me?
Yes, sir.
Very good. I mean, you are a newspaper, you work with the Daily Graphic, so this really falls within your jurisdiction as to what story you write and how you write it. Do you think you would think twice before writing a certain story? Is it in the right direction, or you are a bit skeptical about the powers of the Supreme Court?
Well, the point is not a question about the Supreme Court. I think that what is critical is about exercising freedom and taking responsibility for what you write. So with or without the Supreme Court judgment. I mean, ordinarily, journalists are not just to say or write anything, but they have to ensure that what they are writing is the truth, what they are writing is factual, and above all, we must act in the best interest of the people that we profess to be serving. So I mean, it is not the Supreme Court judgment that may make me think twice about what I'm writing. I take responsibility for whatever I write, and therefore, each time that I take my pen to write, I'm conscious and careful about how I go about, because language use sometimes could be the problem, because the same thing, you can say it one way, it could be a problem, you can say it another way. That's why our elders say that the tongue can bring war, and the tongue can also bring peace.
Staying with you see, sometimes you are writing something, and in your mind or in your conscience, you think, well, it is fair according to how I perceive it. Sammy says, oh, I think the judges are not being fair. Maybe he perceived it at that time, but then the judges said, no, you can say that, but that was his freedom of speech at that time.
Yes. I'm not, the whole question about this idea of the law that impinge on media, including ethics in the media, including contempt of court, including defamation, including copyright, including privacy. I mean, all these laws are intended to strike a balance between the individual's freedom and the collective interest of all of us. So the point is that for as long as in exercising your freedom, it does not impinge negatively on the interest of all of us, then you can do that. But where you exercise your freedom, and that has implications for every one of us, and our collective interest could be jeopardized, that is where we need to strike the balance. And that is where sometimes we have the difficulty. But specifically in terms of contempt, of course, the difficulty for most people is about the fact that, our Constitution says that nothing is a crime until it is defined and the penalty for it is prescribed in a written law. But following immediately after this provision, there is a provision that nonetheless, contempt of court is a crime, even though it is not written anywhere and a penalty is not defined. That is where most people ask that the judges in applying contempt of court must demonstrate some level of circumspection, because at the end of the day, it is only them who understand. It is only them who appreciate what contempt is, and it is only them who determine the level of punishment that must go with that. Whereas in other criminal situations, all of us have, through legislation, defined what the crime is, and we have prescribed the level of penalty that must be applied when somebody falls foul of those laws.
Mr. Ivofor, hold on for me. Is that not the fear? Because it's like contempt, and I'm the Supreme Court judge, so I decide, well, today I feel like this guy is under contempt. I'll give him 3 days, 10 days, or 1 week or something. Is it not a fine line?
It doesn't happen like that. And if you have heard me say that the law is my shepherd, I shall not fear contempt. You see, criticism is not contempt. Criticism is not offense. Even criticism of the most violent nature is not contempt. Contempt is contempt. We ought to differentiate that from criticism. And the judges have not said that they are above criticism. In fact, they have said, and I suspect that you may have heard me quote them in the famous case of the page 28 case, in which they said, and once again, with your kind permission, let me quote. And if you think that the judges are of the opinion that you should not criticize their judgments, they said, in the majority opinion, they said, criticism of the courts and of judicial decisions, however rambunctious, whether or not in good taste, and despite inaccurate statements of fact, would not amount to contempt of court and is within the limits of the inalienable rights of every individual's freedom of speech. If this is what the judges are saying, and they went ahead with Justice Adade admitting that judges, like all other human beings, do make mistakes, they are acknowledging that you can criticize them, you can criticize their judgment, and criticize them in the most violent way that you want to do. But like Yabwedwa Ebuafo said, the laws that empower us to go about these criticisms is the same law that seek to protect us against people maliciously and recklessly running us down. So the law says, I give you the power, but exercise it within certain limits. Exercise it responsibly. Do we say that the Constitution provides that there is freedom of association? For that matter, I can go and belong to an association of armed robbers. We will be living in a jungle. It will not work. I think that the attempt to bring this into the floodlight of freedom of speech and to suggest that that freedom is being shackled, is being fettered, is most unfortunate. It is to suggest that we should live in a country where, because we have the freedom to express of ourselves And the Constitution in Article 21 says, all persons shall have the right to A, freedom of speech and of expression, which shall include freedom of the press and other media. It is this same Constitution that insulates the media and editors from control and censorship. We ought to know that this Constitution is good. And I like Nana Tudazi when he said on Newsfire, he said that we have come very far in pounding the democratic boundaries of the freedom of speech. We should be careful not to do anything that will take us back. And I believe that the forward march is not a forward march of limitless freedom of expression. It is not anywhere. You can't find it anywhere in the world. I hear the examples giving of the United States of America. And I ask people, are you very sure of the examples you are giving? Because if you go to the US, you can count on almost a daily basis suits of defamation. How many media houses in this country have suffered defamation suits? Suits of defamation will collapse the media houses in this country if they were to be pursued in the manner that they are pursued in America. Why? They enjoy freedom in the most liberal form of it, but they also understand that the law must make provision for the protection of the reputation of the individual. The good book says, a good name is better than riches. Your name is all you have got, Nana. And if someone, in the name of political communication, and they do it in such a shallow way, such a propagandist way, in such a way that have no regard whatsoever to the national good, we should sit down and watch everybody in the name of constitutional freedoms or birthrights of freedoms of expression and speech and of the media to run this country down. I think that is unfortunate.
Doctor, you see, in all this, I mean, no politician has a gong beater and goes round every street shouting these defamations. It is we, the media houses, that give them the platform. And I think they are an easy target. They are easy pickings. You know, they are I don't know how to... They want a platform to come and do these things. And as the president says, we are lazy. So we don't want to go and do research and bring somebody who's written a book or something. Oh, no, that's not interesting. Find me one NDC and one MPP guy and I have a show. And so we bring them there and then you stoke the fires and you stoke the fires and bang, you have a show. And then they make headlines and then you have a bigger show. So what is our responsibility in all this?
As the media?
As the media houses.
I think we have a greater responsibility, because if we want to reflect what society does and what the beliefs of society, we must make sure that we try as much as possible to bring people who have expertise. Issues of law, you have a program where issues of law are being discussed. Then we bring in politicians who have nothing to do with law, and they comment on this matter with authority. You have issues dealing with... Can you imagine you have an issue?
Senior, with the greatest respect, they don't comment on the issues. They don't debate the issues. They leave the issues and insult. They abuse.
See, I don't think that if you have an issue bordering on medicine, I'm not qualified. Although I'm a lawyer, I can't speak to those issues. I'm not competent. So you don't bring me on board, because I'll start talking about things which I don't know. And that's exactly what we are doing. We want people who can talk and talk loud. People who can insult. And you see, and the more you insult, the more people see you to be doing well. So that is the situation we find ourselves in now. And everything is about like as we sit here, if it were not to be this control now, you realize that let's bring one MPP. So you want to always to look for, once you have MPP lawyer and you don't get an NDC lawyer, you look for somebody who can manage that lawyer. And that's the situation we find ourselves. So we always like to bring political people with political background rather than people with that competency, expertise to come and talk on issues. If you have people who are competent enough, they will be professional. They have their limits, and it will help us. So that is the way forward. We must avoid bringing people on show. We must avoid interview people who don't have... Can you imagine what happens anytime after the court process, then they rush to Asedu Ketia. You get me right? If a man knows little law, but they just want the man to commit himself. Then quickly, once he goes out there, then St. John also comes in. Forget that it's a legal man. So that's what sells. You see, so we have to be serious as a nation and start looking for people who have the expertise to talk on issues. They'll be more professionals, and then the nation will move forward.
Mr. Ebuafo, I mean, are we not equally as guilty as the gentleman that was hauled before court today? Because, I mean, you and I know, maybe with your institution, not so much, but with the private ones, these are the headlines that bring in, that pay the bills. If you say,
that is, part of our problem also, because you see, we can't do away with our politics. Definitely, everybody has an opinion about something. The critical thing sometimes is that even when you bring a professional, they will talk politics, and that is a problem. I mean, look, so many things do happen in Parliament, on the floor of the Parliament House, for instance, when they are discussing issues, and they know that and the people who are talking are professionals. They will throw away their professional distance and be talking about politics. And that is part of our problem, that this idea of every time that we are discussing something, there must be NDC or MPP representation. It's that part of it that has killed the spirit of knowledge, sometimes. And so what we need to do is, yes, as you're saying, that there are many more people who are guilty of the same thing that some people have been convicted today. At least, I think the last program on the majority caucus, I heard the introductory thing that the host made. And they are more serious, because the way that he was talking like some authority and say that, take it from me as secured and that kind of thing. But, you see, the point that you asked me at the beginning was about the fact that, yes, there's freedom, but the same provision says that freedom must be exercised with responsibility. And indeed, the UNESCO has indicated that to the journalist, freedom and responsibility are indivisible, because there can be no exercise of freedom without responsibility. And also that without responsibility, freedom becomes meaningless. If each one of us will take that and see that, yes, we can express our viewpoints, but the viewpoints that we express must be in the interest of other people, and not that we want to say what we want to say just because we want to score cheap political and that all of us also will not applaud deviance and irritants, because sometimes people make some outrageous statements and then they are heroes. When it happens like that, then the whole society must take responsibility for the irresponsibility of those few individuals. But, the point that I was making about contempt is about the fact that it is the only crime in our law which is not defined anywhere and whose penalty is equally not defined. And so, therefore, it becomes a little bit difficult for people to understand, because if it is about stealing, you know what stealing is. When you go to court, there's a minimum sentence, there's a maximum sentence. If the judge goes below the minimum, they go and appeal. If they go beyond the maximum, they go and appeal. When it comes to contempt, you can't find it anywhere, and therefore it is possible that one judge will say that there's no contempt, and another judge will say there's contempt. Okay, Mr.
Ibuwa, hold on for me one second. I'll just take a quick break, and then when I come back, I need to know two things. If Ken Crancy's posture of, helped or, got him this 10 days rather than the 3 days that his colleague got, and also, will this bring sanity amongst the so-called communicators? I'll take a quick break and I'll come back.
Okay.
Hello and welcome back to the show. I am talking to Dr. Lawyer Maurice Ampao. I'm talking to Lawyer Samson Ladi Ayenini. And then on the phone with us is Yabuadu Ayebuafo of Graphic. But I'll start with Samson. Samson, if Ken had gone there and shown remorse or, humbled himself a bit, would he have got 3 days or less than 10 days? Mighty?
When you're called upon on the question of contempt, it is not straightforward that you go begging or you go seeking to purge. It is whether or not you admit, first of all, that the comments that you have made, which are alleged to be contemptuous, you admit that they are really contemptuous. Now, the Supreme Court, like all other superior courts, derive the power to punish for contempt from Article 126, Clause 2, which says that all superior courts of the land are courts of record and have the power to commit for contempt to themselves. This is what the Supreme Court did. And we're talking about contempt of the criminal nature of scandalizing the court or the resort to scurrilous abuse of the court or its officers. Now, when the court invokes that jurisdiction, there are two things that happen. In on the authority of the Republic versus Liberty Press, which I have referred to too many times now. And I was excited when during the process, Justice Jones Dosey also referred to it and asked Atacha and others to, avert themselves to the position in that case. The position is that the process of punishing for contempt is either summarily or by indictment. It will be summarily if
Can you speak English?
that is you're punished on the spot.
Okay.
I mean, it's a fast track. Immediately, yes, on the spot. Now, instantaneously, that process is invoked if the court takes the opinion that the matter alleged to be contemptuous is, quote-unquote, clear and unambiguous. It is clear and unambiguous. In that way, they will invoke the summary jurisdiction. But if it is otherwise, they will invoke the indictment jurisdiction, which means that in this matter regarding the court, the Attorney General would be invited. And you heard Justice Atubga say they may refer it to the to the Attorney General. So it was either that the court would have taken Ken Kranche's posture as that he was contesting their claim, and they found that their claim was clear and unambiguous on the face, and so they can punish him summarily, or that when he attempted to contest it, they found that the thing needs a bit of clarity to be able to come to a conclusion that it is a contemptuous remark. Then they would have made a reference to the Attorney General, and the Attorney General would have initiated the committal proceedings, would have filed an application, attached to it an affidavit, and in the affidavit he will state the various particulars for why Ken should stand trial. And then Ken will be afforded the opportunity to also file an affidavit in opposition, also stating why he feels that the comments he made are not contemptuous. And then the court will come to a determination. If it comes to the determination that he is guilty, he could suffer either the maximum of the 6 months in jail, or often you never get to suffer all of it, or you could get a fine. In default of the payment of the fine, then you get jail, or you could get both fine and a jail together. And I think that it appears that people are not reading, and so they have a difficulty in understanding the processes that were followed. In fact, if you go to the civil procedure, the CI 47, which we use for the superior courts, particularly the high courts and the circuit court, you would find in Order 50, Rule 2, that the court says that you can dispense with the processes of the application. The court can decide to dispense with the processes of the application, and so motu, on its own motion, invite you and ask you to justify why you should not be punished for contempt. And I find that it appears that that is what the court used today.
Doc, I'm going to go to, do you think this will shake the system and sanitize it a bit?
Yeah, it will shake. But let me add to that. Today I was so sad and I think Ken Crunchy is cancelled today disappointed me a little bit, because you realize that the 9 justices, clearly from their posture, have taken a position, as my brother is saying, that the matter is contemptuous. If you read the statement that was made to that, so contemptuous, so it's difficult to defend at that time when they are using the summary medicine, and they gave a signal. You know, when counsel started trying to argue, and then also ended up even lecturing that, and then making the Supreme Court know that, look, there's even confusion as to among lawyers as to even where the thin lines. And then in struggling to defend, he could not defend the issue. Please send a signal to your counsel, because I'm sure there has been a conference, and to be like, go there, we are going to defend you, and don't go and concede.
No, but Senior, it could be the case also that he felt that it could be the case that they were not going to use a summary process, and that he was expecting. If you listen to him, it appears he was expecting that it was going to be an indictment process. In that case, the Supreme Court had actually given an indication. Justice Atugwa has said, we may have to refer this to the Attorney General. So I suspect he was expecting that this will happen. So it will be referred to the Attorney General, and the processes will be gone into. He will have the opportunity to defend himself in the process. But like you said, sometimes they give you a signal. And like Oliver Wendell Holmes said, that the prophecies of what the court will do in fact, and nothing more pretentious, are what I mean by the law. Sometimes we can predict them. When you predict them, you take a cue.
They gave the signal. You know, you got to a stage, they realized that the counsel was not helping things. Then they threw it back to Ken Crunchy that, look, now we want to talk to you. And they gave him opportunity.
That's when he should have
changed his tone. But he was looking to counsel, and all of a sudden, even when they gave you opportunity now to say, I'm sorry, you said if. You get me right? Then the if second time. So you realize that, you look at the ruling that came.
No, you see, on that point too, where he said if, qualified the apology, conditionalized it. If it is the case that their suspicion was that it was going to be an indictment process, then the court would have rejected that apology. In the same way, you are called upon to answer to a charge. If in a criminal process you are called upon to answer to a charge, and you don't plead guilty, and you don't plead guilty, you don't also plead not guilty, and your plea is not very clear, the court normally will enter a plea of not guilty for you and give you the opportunity to defend yourself.
They were not prepared to go that way. You could see clearly that the man even asked whether they charge it, and they were saying, what kind of charge it?
I want to give Mr. Ibuafo.
Yes, sir.
Very good. You know, Sierra Leone was once upon a time the most peaceful country on earth before they decided to take machetes and chop people's arms, you know, long sleeve or short sleeves. You had to pay $3 to get shot or hacked to death. Liberia was one of the happiest places before they tore their country apart. Isn't it amazing that they are still, I don't know whether to say educated or learned people amongst us who are upset with the Supreme Court for trying to stop things like this from starting, because it all starts, you know, with radio, you know, Rwanda, and the examples are many. Aren't you amazed that there are still, you know, educated people amongst us who are...
Yeah, but you see, the problem is about politics, you know. Even in Rwanda, if you go into it, you realize that it did happen because there was support from the presidency. You know, some of these things, it is because of politics. I think that we have allowed politics to drive us, and we use politics in determining the guilt or otherwise of people to the extent that people, depending on where you stand, you don't fear what you say. Because you know that politics may come to your aid. You know, and I think that maybe it was good that this thing was done somewhere rather than on conviction. You know, otherwise, you know, the Attorney General entered into the fray to create it would have created its own politics, you know. And the important thing is that sometimes, and it is important for all of us to realize that in the face of contempt not being defined, it is a matter of you against the judges. Once the judges are convinced that the matter is contempt, I think that you don't have to challenge them. At the end of the day, they are the ones who are going to make the decision. And the law says that they can commit it for contempt by themselves. So what are you going to do about that? And so when it becomes clear, because I went for a copy of the paper, I mean, when the matter came out, to read and see what the issues were. And when I looked at it, I said, well, he's arguing that there's a lot of innuendo in those questions. And that it's not a straightforward, innocent question, but it is a question that is loaded with prejudice. You know, so, I mean, once it dawned on this, and the critical thing after all this thing was to say, you are sorry for what you did. You did not, after all, I mean, when our elders tell us that the patrol solves a lot of problems, you know. So I think that maybe it's 10 days. 10 days is not long enough. I would have wished that they had all been given in the same kind of thing, but somehow I think that are too bigger. You know, I was confusing the name with the justice, but I realized that one is BI and the other is GU, so that makes the difference. He immediately, the way that he spoke, I listened to him on the radio, and how his posture was so different after his name was mentioned. And so you could see that, well, this is from somebody who might have had some ego, some inflated ego at the time that he was talking, thinking that he was above reproach and all that. But the moment that it dawned on him that there's some authority beyond him, I think that he sobered.
Thank you very much.
And so that is the way.
Thank you very much. Well, viewers, joining me to discuss this issue as to whether freedom of speech is under threat. On the phone was Mr. Yaobuedu Ayeboafo. In the studios with me is Dr. Maurice Ampa, who's also a lawyer, and then Samson Ladi Ayenini, our own brother and legal luminary of multimedia.
Legal what?
Luminary of multimedia. I'm not going to get in trouble, am I?
Yeah.
I am Nana Sakwao. And I think it's clear. Let us all be responsible. You know, freedom of speech, but I think the freedom of the nation supersedes everyone's freedom of speech. And to you out there, my brothers in the media, come on. Let us all also take our responsibility and play our part to make sure that we have a safe country to live in. Tomorrow we'll be back here to do it all over again. Thanks for watching.